Okay, I'm going to call this meeting to order. I'm going to call it to order. We don't have order. We haven't even started yet, so we're off to a great start today. There's been some discussion after last time whether it was suspended or adjourned. The chair today, myself, believes that we suspended last Thursday, so I will, and there was a unanimous consent motion at the end of that to continue debate at the next meeting. So I'll continue with that UC motion.
Point of order.
Give the floor to Mr. Motz.
Point of order. Mr. Chair, can you please pull up the ruling where there was a unanimous consent motion, number one, and number two, through you to the clerk. The clerk in the minutes that he created, what does it say? Does it say that we suspended or adjourned the last meeting? What do the minutes say?
The last meeting was adjourned, but but our UC at the end of that, and we all voted on that, was that we were going to continue with the discussion in our next meeting. I see Mr. Julian has his hand up. Mr. Julian, thank you for putting your hand up politely and asking for the floor. I appreciate that.
Thank you, Mr. Chair. We have witnesses that are here, and I believe we need to hear from them. You'll recall the last meeting was truncated and we weren't able to fully question the witnesses. We also have witnesses coming at 4:30. So I would suggest that we have that conversation offline and that we proceed to questioning the witnesses.
We can do we have agreement that there was UC at the end of the last meeting to continue on? No. You're shaking your head no. We did not vote on that? To continue debate? Everybody wants to debate whether we discussed that and voted on that?
Un rappel au règlement, Monsieur.
Just one moment, please.
Point of order, Mr. Chair. My understanding of the last meeting, I remember that I heard Mr. Motz say that he wanted us to adjourn the debate on the motion that he had presented. That's what I remembered. Maybe I'm mistaken. I don't remember that there was a unanimous vote or unanimous consent to continue the discussion on this motion. In addition, we were able to question the witnesses, and now we have new witnesses today. Maybe we could let them give their opening statements, but maybe the clerk could tell us how the last meeting ended. But to my mind, Mr. Motz had asked the adjournment of the motion that he had proposed.
This point of order, I was definitely sitting in the room, and I definitely remember a UC motion that we all agreed to let Mr. Motz carry on and to suspend to allow the witnesses. I believe there were some hands up over here. Mr. Motz, you had your hand up?
Yes, a couple of things. First, the original notice of meeting that came out on for today from Friday afternoon was committee business resuming debate on the motion of myself. And then an hour later, actually 61 minutes later, a new notice of meeting came out, and I don't know why, which the committee business was deleted. So I suspect there must have been some pressure from somewhere, unfortunately on the clerk, to adjust it. But I'll take you back to the blues from last meeting. Now, Mr. Julian made an intervention about the witnesses, and I indicated that I initially said to adjourn the motion, and then I corrected it to say to suspend the motion, and that's where we were at. That the motion was not moved to adjourn; it was suspended. And if you want to look at the blues, I encourage you to do so. And so that's where we are at today, based on the history of the meeting last week. So then, when the chair asked, "Is the agreement of the committee to suspend?" The chair said, "Okay, to our witnesses, we'll suspend for 2 minutes while we get our witnesses in place." So that's what happened. So whether or not it says, is the agreement to have to the committee to suspend, and the motion was agreed to, it says in the bracket. So that's all I can provide as to the history of last meeting.
I had Mr. Lloyd next, and then Miss O'Connell, sorry.
Well, I mean, just to reiterate that Mr. Mott says the Blues, and the Blues were very clear after Mr. Julian's suggestion that we suspend the meeting, and there was unanimous consent to suspend the meeting, and that is my recollection of how the last meeting ended, and my full expectation is that we will resume exactly where we left off in the last meeting. Thank you.
Ms. O'Connell?
Thank you. Thank you, Mr. Chair, but Mr. Mott's just made the point. He moved to suspend the debate. There was no clarification on when that debate would then continue. We moved on to C26. The meeting did not suspend. The meeting adjourned. There is a new notice of motion. Therefore, if you would like to lift the suspended debate back to the floor, you would require a dilatory motion. It doesn't just continue because the meeting adjourned and the debate was suspended, but there was no time and place given. There was no agreement that it would start off at the beginning. And if you can point that out in the Blues, I'm happy for you to read that, but I know it doesn't exist. Therefore, you require a motion to bring the suspended debate back to the floor. Otherwise, the notice of motion is here. The notice of meeting is here, and that's what we move forward on because the meeting itself adjourned. And so if the Conservatives would like to, again, we have witnesses here. They don't seem to care about safety. And I find it interesting, Mr. Chair, on this point. Today we're seeing in Atlantic Canada, historic snowfalls where Canadians and people there, and Cape Breton in particular, are worried about, being able to get out, being able to access resources. And C26, actually part of this legislation, deals with ensuring the sustainability of telecoms so that in the event of a natural disaster, like what we're seeing in Atlantic Canada right now, that there are literal lifelines
Ms.
still
O'Connell,
available.
We're still on points of order, not
right,
debate.
and I have the floor, and I'm
I know, but
talking
sounding
about
like debate. So can you make your point of order, please?
Oh, I guess the chair and the Conservatives think it's debate to talk about the safety of Atlantic Canadians and the very legislation we're trying to deal with that would actually create a system to ensure that in events like
Point
this,
of order, Mr.
that their
Chair.
telecoms are protected. So if you
we're
want
legally on a point
to,
of order right
if
now.
you want to move a dilatory motion to not go to C26 and deal with that, then I think you can explain that to Atlantic Canadians today too.
Okay, just before we go, we have a couple more hands up on this issue. Maybe I can ask the clerk. And I got a little confused too. As the chair, I'm asking now, how were those two different meeting notifications given out so closely and yet so differently? Could you please clarify us on that?
Mr. Chair?
So,
On the same point of order?
Chair, and then we got 2 points there. I'll get you on the list though, Mr. McKinnon.
so the clerks follow the instruction of the chair unless there's any indication from the committee on what's to put on the notice of meeting. So,
Okay, so you were re-instructed to make a second one to get that out?
so I follow the chair's instruction for the notice of meeting. Yes.
Okay, Mr. Mott, your hand. Oh, I think I had you next. Oh, I thought yours was a point of order. Pardon me.
So, thank you, Chair. I just want to clarify again in the Blues, when we were talking about suspension, whether an adjournment, and I had the floor on the motion, and I said I did not move a motion. I'm agreeing with Mr. Julian to say let's go to C26 for the remainder of our meeting today, and I'll pick this up at the next meeting, is what I said. And then Mr. Chair said, is it the agreement of the committee to suspend? And then the notes say in the Blues, motion agreed to. So as I understand the rules, that motion and the conversation about that motion and the debate on that motion is suspended from last meeting, and we went on to the witnesses. Now, today, In order to wrap up that motion, I have a couple comments that I wish to make that should take no longer than 15 minutes or so. And then, we have other speakers on that list. If they wish to continue to speak, then that's certainly their choice. But as I understand the situation from last meeting, that we were into a suspension on the motion. And because of Mr. Julian's intervention, I agreed to let those witnesses at that time, and I gave up the floor on a suspension to deal with that. Thank you, Chair.
Thank you. So if we would have went right into your comments, we'd probably be wrapping it up right now and moving on. Mr. Lloyd, you heard the next? Oh, you're done? Mr. McKinnon?
Yeah, I don't know what was in the mind of the chair as he made these preliminary schedules, but I think he had a hard think on what went on and decided this was more appropriate. I think that whether or not we suspended or adjourned that motion or that discussion, it becomes moot if we realize that Mr. Motz or someone else could resume, could remove the motion when the time comes. But I wonder if we could have an agreement to hear from the witnesses first, and have at least one round of questions for the witnesses before we did so. So that would be a suggestion to Mr. Motz.
Sounds like probably a good compromise to me, but we'll see what Ms. O'Connell says.
Mr. Chair, I move that we move to the business of C26.
So you're not agreeing with Mr. McKinnon's compromise?
I move that I move my motion that we move to the business of C26. I'll ask for a recorded.
I will ask the clerk for a recorded vote on that, please. Thank you.
Ms. O'Connell.
Yes.
Mr. Biddle.
Yes.
Mr. McKinnon.
Yes.
Mr. Gair.
In favor?
Monsieur Chiffquet. Monsieur Chiffquet. Yes.
Oui.
Mr. Lloyd.
No.
Mr. Motz.
No.
Mr. Lippert.
No.
Madame Michaud.
En faveur.
Mr. Julian.
No.
So it's 6-4 in favor.
Maybe you got his vote as a no, right? All right. Okay. So we will start with C26 after that vote. What we will do, if I have a nice preamble here, introduce everybody. To save some time and to give you folks a little bit more time, maybe you could, I know this is very informal, say your name at the beginning of your 5 minutes and hopefully give you guys a little bit more time because we've already lost some time going into this. So we will start with our witnesses. And who's up first? Sorry.
Say Mr. Shipley.
Mr. Shipley, you want to go first? God, that rolls off the tongue nice, doesn't it, Mr. Shipley?
Shipley. Good afternoon. My name is David Shipley, and I'm the Chief Executive Officer and co-founder of Beauceron Security, Inc. I'm also the co-chair of the Canadian Chamber of Commerce's Cyber Council. I'm a proud Canadian Forces veteran, having served with the Canadian Army Reserve and the 8th Canadian Hussars. I'm not a computer scientist. My expertise and perspective today are based on my experience as CEO and co-founder of Beauceron. I do not see cybersecurity as a technological issue. It's a people and business risk issue. I founded Beauceron Security in 2016. We now serve more than 750 organizations in Canada, the United States, Europe, and Africa. We have helped more than 650,000 people learn how to spot, stop, and report cyber attacks. Beauceron Security has demonstrably reduced individual and organizational cyber risk. Our Made in Canada solution is used by global banks, national telecommunications carriers, educational institutions, healthcare facilities, government, and small business. We live in a world where North Korean hackers steal billions of dollars of cryptocurrency to fund their nuclear weapons programs. Something that 25 years ago would have sounded too far-fetched to be even the plot of a James Bond movie is an all too real reality and contributing to global instability today. It's also a world where a Canadian federal government IT worker by day becomes one of the most successful ransomware affiliates by night, making millions of dollars as a digital extortionist for an international criminal gang. I share these real-life examples because they highlight the first point I want to make. When it comes to cyber, anything, even the bizarre, is not just possible, it is the norm. The challenge of managing cyber risk is to balance the incredible creativity of humans with the unpredictability of complex digital systems. I know for many, this topic can be overwhelming. You may feel many feel they do not have the technical background to think about these issues. You may also feel, as legislators, that this is difficult to wrestle with this law. But please, this is not a technology issue. Throughout my career in cybersecurity and as a CEO of Beauceron, the root cause of every single cyber incident our customers and we have ever helped investigate have always been traced back to the combination of people, process, culture, and technology. Cybersecurity has never been about technology alone, and it can never be solved by technology alone. The story has always been, and will continue to be, about the relationship between technology, people, and control, which is, by the way, the actual meaning of the word cyber. Reducing cyber risk to Canadians will require legislation and a regulatory regime tailored and developed collaboratively with industry. These regulations and directives must look at people, process, culture, and technology-based risk controls. I support the need for this legislation. We need this law now more than ever. We are far behind our allies, and we are risking the safety and prosperity of Canadians every day we delay. This legislation and the accompanying regulatory regime must ensure a proactive, positive security culture is instilled and maintained within Canada's critical infrastructure firms. With some fine-tuning, I believe it can accomplish these goals. I support the recommendations put forward by the Canadian Chamber of Commerce to improve the bill to ensure fairness, effectiveness, and proportionality of the proposed legislation. In addition to their recommendation, I urge the committee to look at the following issues. Number one, add due diligence defenses to the proposed administrative monetary penalties. We need to create positive reasons to invest in security and compliance with legislation, not just negative consequences for failure. Number two, remove personal liability for individuals. At a time the cybersecurity labor shortage is most acute, and when as many as 75% of the most senior cybersecurity leaders are considering a career change out of cybersecurity, adding a target on their heads will only make things worse and subvert the objectives of this legislation. Ensure regulators charged with creating industry-specific cybersecurity directives have the skills required to do so effectively. While regulators such as the Office of the Financial Superintendent are experienced, others are giving responsibility for cyber for the first time. This legislation should require government collaboration with industry, such as what has already been done with the Canadian Security Telecommunications Advisory Committee. Lastly, and considering the recent news about global affairs, this legislation should limit the amount of sensitive data collected by regulators about cybersecurity defenses of Canadian critical infrastructure, lest we inadvertently create a one-stop shop for hostile nation-states and criminals to learn how to cripple these vital sectors and firms. The opportunity before you with C26 is to ensure that the Canadian people...
Are you just about wrapped up?
Just about wrapped up. Through Parliament, are in control of the technology that they rely on for the functioning of our society. Not the technology itself, not the technology companies, and certainly not our adversaries. Thank you.
Thank you. Next we'll go to Ms., and I'm going to try this, Ms. Bar Gedalia. Thank you.
Mr. Chair, members of the committee, good afternoon. My name is Ulrike Bar-Gedalia, and I'm the Senior Director of Digital Economy, Technology and Innovation at the Canadian Chamber of Commerce. I'm also the Canadian Chamber's Architect and Policy Lead for the Digital Economy Committee, Future of Artificial Intelligence Council, and Cyber Right Now Council. As Canada's largest and most activated business network, representing over 400 chambers of commerce and boards of trade, and more than 200,000 businesses of all sizes from all sectors of the economy and from every part of the country, the Canadian Chamber is pleased to have this opportunity to provide feedback on Bill C-26. Our Cyber Right Now Council has been calling on government to prioritize cybersecurity and focus on a prevention-first approach and improved information sharing for close to 3 years. Today, I'd like to share a few key recommendations and why cybersecurity is important to the Canadian Chamber and our members within the Canadian economy. Over 98% of Canadian businesses are small or medium-sized enterprises. SMEs need greater cybersecurity threat awareness, protection, and training to utilize the full suite of tools at their disposals and to keep Canadians safe from bad actors. Just as in other countries, Canada is facing an increasingly complex and risk-prone digital landscape. With a cybersecurity skills gap of some 4 million people globally and an ever-increasing number of connected devices, at least 67 billion and counting, the challenges and costs associated with securing our digitally enabled world are increasing. But while every organization of every size and in every sector is at risk of a cyber breach, few carry the same real-world risk of a crippling cyber attack as those in the critical infrastructure sector. This threat will only grow as our critical infrastructure increasingly relies on software and connected technology to power and support its operation. We are pleased to see Bill C-26 proceed to committee study and support the bill overall. However, certain amendments are needed to ensure the bill reaches its full potential. More specifically, our telecommunication members have expressed their concerns with respect to a few provisions in the Telecommunications Act, such as the lack of a due diligence defense for violations under Section 15, Part 1, resulting in monetary penalties and the extent of ministerial order-making powers. I will note that this defense is present elsewhere in Bill C-26, such as in relation to cyber directions in Part 2, the CCSPA, as well as full due process for and parliamentary oversight of ministerial orders. I encourage the committee to reach out to the telecommunication providers, as it's important to hear from them firsthand. With respect to the CCSPA, our members are seeking the following improvements. Firstly, a clearer definition of a reportable cybersecurity incident. This will ensure industry isn't forced to report events that do not pose a material threat to a vital system. Failure to clearly define the parameters for reportable incident will undermine the purpose of C-26 and overwhelm government authorities who will have to process and assess each cyber incident reported. Secondly, allowing for a 72-hour reporting period for cybersecurity incidents as opposed to immediate reporting. Allowing for reporting within 72 hours provides organizations the time to investigate and will harmonize with existing regimes, such as in the United States, one of our key trading partners. And finally, two-way information sharing is crucial. As currently drafted, the CCSPA only contemplates one-way information sharing from designated operators to the government. We believe this is a missed opportunity and potential weakness and underscores my earlier noted prevention-first approach. The more information we have, the more we can work together, and the better we can help prevent incidents. Thank you for listening and for the opportunity to participate in the study of Bill C-26.
Thank you for that. Next, we'll go to IBM Canada. We have Ms. Dana Proctor and Mr. Tiole Traore. Fairly close. I tried. Thank you. Whoever wants to go there or both. Thank you. You have 5 minutes.
Merci, Monsieur le Président. I'm Tiole Traore. I'm the Head of Government and Regulatory Affairs for IBM Canada. And on behalf of IBM Canada, I would like to thank this committee for the opportunity to testify on C-26, and more specifically on Part 2, the focus of our testimony. The digitization of the global economy has increased the need for governments and businesses to protect themselves from constantly evolving cyber threats. Strong cybersecurity protocols should be viewed as digital foundations for all entities seeking to maximize the power of tools such as cloud, AI, and quantum computing. IBM souscrit pleinement au principe de C26.
IBM readily endorses the C26 principles. Canada should ensure that the critical infrastructure on which its citizens depend are properly protected against cyber threats. The staggering growth in the number of cyber attacks is a global phenomenon that does not spare our country, so it's crucial that we do something about it. However, to ensure that this bill truly maximizes its scope and delivers immediate and long-term benefits, IBM maintains that C26 should be amended by this committee with particular emphasis on 3 points: clarifying the definitions, aligning the Act with international standards, avoiding potential excesses.
Dana Proctor. I'm the Canadian Cybersecurity Executive with IBM Canada, and it's a pleasure to be with you today, speaking on the topic of Bill C26. There are 3 items that I'd like to talk with you about today. First one being clarifying the core definitions within C26. Currently, C26 leaves much of the scope of the legislation to regulations. We believe that it's critical to clarify the scope and the definitions in the legislation itself, rather than delegate to the regulatory processes. Key terms used in the proposed law, such as designated operators, confidential information, security, or significant incident, are either too broadly described or not adequately articulated. We believe this committee should aim to address these definitions as much as possible, as this will enable a common understanding and increase enforceability, as well as speed up the review when it comes time to drafting the ensuing regulations. Second, alignment with international standards. Canada's strategy and approach should be inserted into the collective efforts of our international community. As drafted, C26 carries various provisions that are not aligned with other mature cybersecurity regimes. The legislation does not differentiate between security levels of breaches. Furthermore, it includes potential incidents within the scope of its incident reporting obligations, which could serve to overwhelm regulators with unnecessary and unhelpful information and place an unnecessary burden on industry. The legislation's immediate reporting of cyber incidents without a formal definition as to what would constitute immediate is also problematic. Most jurisdictions allow for a 72-hour reporting window to allow injured parties to understand what has transpired, which in turn ensures that regulators receive a comprehensive report about actual findings. The court has unfettered and overly broad jurisdiction where under an act they can impose criminal conviction, imprisonment terms, an uncapped fine, and personal liability with administrative monetary penalties in the amount of $15 million that can accrue. This represents an entirely new regime and significant penalties far and above those under other comparable pieces of legislation. The severity of such penalties and the enforcement action that may be taken invariably will create a chilling effect. Respectfully, the enforcement action that may be taken against individuals should be removed, or to the extent that such liability is considered necessary and proportionate, at a minimum there should be a defined standard to demonstrate the objective and substantiated culpability. Lastly, avoiding government overreach. While IBM recognizes the need for compliance and oversight, we specifically suggest clarification and a refinement of the authorized powers belonging to the regulatory authority or persons who have the ability to enforce the provisions. Namely, the ability to attend facilities, examine documents and records, mandate internal audits, unilateral broad discretion, impose remedial actions. All of these, we strongly encourage that these regulatory authorities and government access rights be limited in their scope and be limited to certain critical situations that meet specific non-compliance thresholds. In conclusion, IBM believes that the clarity around key definitions, enhanced harmonization with international standards, and clear safeguards from potential government overreach would strengthen C26 mandate. Thank you for your time. We welcome and look forward to addressing your questions.
Thank you for that. You must have been practiced a little bit because that was almost exactly on 5 minutes, so good job. We'll start off with questions, and I believe, Mr. Mott, you're up first.
Thank you very much, and thank you to the witnesses for your testimony and for being here today. One of the things that you probably noticed at the front of this meeting is we've been seized with a decision from the federal court, where the federal court found that the Trudeau government's use of the Emergencies Act was illegal and unconstitutional. And as a result, we've been having that conversation here. And I know this might just derail the questions to you, but Chair, I'd like to move a motion, please, that is duly on record, and moved or presented to the committee that in light of the recent federal court ruling, which found that the government's use of the Emergencies Act in federal of 2022 to have been illegal, and that the special criminal laws subsequently created by the Liberal cabinet to have been unconstitutional let me try that again. That it has been illegal, and the special criminal laws subsequently created by the Liberal cabinet to have been an unconstitutional breach of Canadians' charter rights. The committee undertake a study of 7 meetings pursuant to Standing Order 1082 of the Department of Justice's role in supporting the government's illegal and unconstitutional decisions concerning the Emergencies Act, together with the consequences which follow the court's decision, provided that A, the committee invite the following to appear separately as witnesses for at least 1 hour each. 1, the Honourable David Lemeni, the Minister of Justice and Attorney General at the time. The Honourable Marco Mendocino, the Minister of Public Safety at the time. The Honourable Arif Farani, the Minister of Justice and Attorney General of Canada. Representatives from the Canadian Civil Liberties Association and representatives of the Canadian Constitutional Foundation. B, an order to issue for all legal opinions which the government relied upon in determining that the threshold of threats to the security of Canada is defined by Section 2 of the Canadian Security Intelligence Act, required by Section 16 of the Emergencies Act, had been met. 2, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. 3, the situation could not effectively have been dealt with under any other law of Canada as required by Section 3 of the Emergencies Act. 4, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And 5, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that these documents shall be deposited with the clerk of the committee without redaction and in both official languages within 7 days of the adoption of this order. Now, Chair, I think it's important that Canadians at least have a brief summary.
Point of order.
Yes, Mr. McKinnon.
With apologies to Mr. Motz, I would renew my concern as expressed when this was last moved, that this exceeds the powers of this committee. I understand that this matter was taken under advisement and will be reported back at some time once wiser heads have been able to wrestle with it. I just wanted to put that on the record.
Since we have different chairs today, I'm not sure where he is on that decision, and we'll let Mr. Motz continue now, but thank you.
Thank you, Chair. Like I was saying, I think it's important that Canadians at least have a brief overview, a summary
Point of order.
of this particular order.
Thanks. Can I get a clarification on what motion Mr. Motz is moving? Is this the same as the other day, or is this a new one? And if so, can you point to which motion? There were like 6 tabled.
It's 1.1. That's what the clerk is indicating to me. The notice of motion, Mr. Motz, dated Tuesday, January 30th, 1.1 Emergencies Act motion.
Is this the same that Mr. Motz moved at the last meeting?
No, it is a different
Okay,
motion.
that's what I wanted to clarify. Thank you.
Go ahead. Oh, sorry, Mr. Motz.
Thank you, Chair. As I was saying, maybe third time's the charm. Canadians need to understand and deserve to understand a summary of the decision, at least for today, on what the decision was and how the Mosley decision impacts the government. Now, as we know, on January 23rd of this year, the Federal Court of Canada released its historic decision into the judicial review of the Trudeau government's invocation of the Emergencies Act and the regulations made under it in response to the 2022 Freedom Convoy. We all know that the Emergencies Act is extraordinary legislation that upends our normal constitutional order and grants sweeping powers to the Prime Minister and Cabinet, including the power to create new criminal laws at the stroke of a pen. The Emergency Act had never been invoked before February of 14th of 2022, and its use against mostly nonviolent protesters concerned about the federal COVID-19 policies and mandates was disturbing and is disturbing. Many Canadians, myself included, believed all along that the decision was illegal. We believed that the high threshold to invoke the Act, which is a tool of last resort, was not met. We believed that the new criminal laws created by Cabinet under this Act, which prohibited attending convoy protests and froze bank accounts even without reason to suspect a crime had been committed, were unconstitutional. Justice Mosley found that the high threshold to invoke the Act was not met because there was no national emergency and there was no threat to the security of Canada as defined by the legislation. And the regulations violated the Charter of Rights to freedoms of expression and security against unreasonable search and seizure, and that those limits were not justified. Now, just to go through a few of the points that Justice Mosley spoke about. The bottom line is his opinion and his decision was that Cabinet was not owed extraordinary deference when interpreting the Act. One of the more galling claims by the government was that Cabinet is owed near total deference when it comes to anything to do with an emergency. Justice Mosley rejected the government's proposition, finding that while Cabinet is owed deference because it needs to respond to fluid situations quickly, there is no untrammeled discretion, and Cabinet is nonetheless constrained by the objective thresholds written into the statute. Secondly, there is no national emergency within the meaning of the Act. To invoke the Act, there must be a national emergency. If the effects of the emergency do not extend to the whole of Canada, the area to which they do extend must be specified. The Trudeau government claimed the emergency existed throughout Canada. Justice Mosley called this an overstatement and found that the provinces were able to deal with the situation using existing laws such as the Criminal Code. And to quote paragraph 248 of his decision, Justice Mosley says the proclamation stated that it existed throughout Canada, and this, in my view, is an overstatement of the situation known to the government at the time. The majority of the provinces were able to deal with the situation using other federal laws, such as the Criminal Code or their own legislation. He goes on to talk about the Emergencies Act as a tool of last resort. Now, Justice Mosley affirmed the federal court decision that the Emergencies Act is a tool of last resort. In paragraph 253 of his decision, he states that due to its nature and the broad powers it grants the federal executive, the Emergencies Act is a tool of last resort. The Governor and Council cannot invoke the Emergencies Act because it is convenient or because it may work better than other tools at their disposal. In this instance, the evidence is clear that the majority of the provinces were able to deal with the situation using other federal laws, such as the Criminal Code or their own legislation, as I said previously. The next area that he talks about is that there were no threats to the security of Canada within the meaning of the Emergencies Act. Justice Mosley found that there was no threat to the security of Canada within the meaning of the Act. The Act says those words have the same meaning as in the CSIS Act, which includes the threat of serious violence against persons or property. Justice Mosley noted that the head of CSIS did not believe that that definition was met. The only specific example of threats of serious violence provided were weapons uncovered at Coots. But that situation was already dealt with by the RCMP using the Criminal Code before any of the extraordinary regulations were created. Justice Mosley moves on to the economic harm, and he suggests that the economic harm is not part of the threshold to invoke the Act. The government claimed during the Rouleau Commission and during the federal court hearing and in press conferences following their loss that a threat to the security of Canada can include economic harm like damage to supply chains. Justice Mosley found that the harm being caused to Canada's economy, trade, and commerce, although concerning, it did not constitute threats or the use of serious violence to persons or property as required by the CSIS Act definition. He goes on to say in paragraph 296 of his decision that for the test for declaring a public order emergency under the Emergency Act requires that each element be satisfied, including the definition imported from the CSIS Act. The harm being caused to Canada's economy, trade, and commerce did not constitute threats or the use of serious violence to persons or property. Mr. Justice Mosley goes on to talk about the attendance and the issues not only illegal by the Act but also by the Constitution. Banning mere attendance at protests violated the freedom of expression under the Charter. Justice Mosley suggested that the regulations limited the right to freedom of expression guaranteed by Section 2B of the Charter by banning anyone attending an assembly that may be reasonably expected to lead to a breach of the peace, rather than simply prohibiting conduct like blockades and excessive honking. The violation of expression, Mr. Justice Mosley found, was not reasonable, and not a reasonable limit, sorry. Justice Mosley ruled that the measures that infringe Section 2B could not be upheld.
Point of order, Mr. Chair. Point of order. Thank you, Chair. Listen, Mr. Motz, it seems like you're going to be going on for quite a while, and last time he didn't leave colleagues express themselves on the motion. I imagine we won't have time to ask questions of our witnesses, so I wonder if he could indicate for how long he will be going on so that we don't have these people who've made the effort to come here to share their expertise on Bill C-26. So otherwise, I propose we vote on Mr. Motz's motion so that we could come back to the study of Bill C-26. I don't know if he would agree to this proposal.
Much of any idea how much longer you will be?
Thank you, Chair. Probably 5-8 minutes max.
Okay. 5-8 minutes? Okay, we'll let you continue. Thank you.
Thank you.
Yes, Mr. Julian?
Yeah, on a point of order. I think the way this committee has dealt with issues in the past is we have discussions offline, we come back to committee. I have some things, amendments that I'd like to offer to the motion possibly. I think this is something that we could have a full committee meeting on, but I am conscious of the fact that we have witnesses and costs that have gone to the Canadian taxpayer and witnesses that are offering important testimony on a bill that is vitally important and that has languished now for almost 2 years. It is, I believe, our responsibility to question the witnesses. I would ask Mr. Motz would just suspend his discussions so we can have some talks offline and question the witnesses, which was really the intent of this meeting today. And I think we could probably come to a consensus in the coming days prior to the next meeting.
Mr. Julian, thank you very much for that. Unfortunately, Mr. Motz does have the floor, and I will reiterate Mr. McKinnon did bring up a nice concession earlier that was not agreed to. So I think, Mr. Motz, I can't direct you in this, but if you could wrap it up within 5 minutes or so, it would be nice to get back to the witnesses, but it's up to you and the floor is yours.
Thank you very much. And to Mr. Julian's point, I thought I had a gentleman's agreement with the committee last time that was proposed, and that certainly got tossed. So I will finish within 5 to 7 minutes, Chair. Thank you. So, as I said, the violation of freedom of expression was not a reasonable limit. Mr. Justice Mosley ruled that those measures infringed on Section 2B could not be upheld under Section 1 of the Charter, which allows for reasonable limits where there are demonstrably justified in a free and democratic society. He found the measures were not minimally impaired or impairing in 2 ways. First, they were applied throughout Canada when they could have been applied to or limited to Ontario and maybe possibly Alberta. Second, there were less impairing alternatives available that the government was constitutionally required to select were the measures they chose. He got into the freezing of bank accounts, and he ruled that they violated the right to be free of unreasonable search and seizure. Now, Mr. Justice Mosley also ruled that the measures ordering banks to disclose banking information of persons designated by the RCMP and freeze their accounts violated the right to be secure against unreasonable searches and seizures under Section 8 of the Charter. The searches of bank records were not reasonable because they required banks to inform the RCMP if they had any reason to believe someone was materially assisting the protests, when a search normally requires that police prove to a third party on an objective standard like reasonable suspicion or reasonable grounds to believe that a crime had been committed before the search takes place. In paragraph 337 of his decision, Justice Mosley says the absence of any objective standard was confirmed by Superintendent Boudin, who acknowledged in cross-examination that the RCMP did not apply a standard of either reasonable grounds or a standard of reasonable suspicion, and all that required was bare belief. In 341, Justice Mosley goes on, I find that the failure to require that some objective standard be satisfied before the accounts were frozen breached Section 8 of the Charter. And lastly, on a note, the brief overview, the search and seizure violation could not be justified under Section 1 of the Charter as well. Justice Mosley found that there was no threat to the security of Canada within the meaning of the Act. The Act says those words have the same meaning as is in the CSIS Act, which includes the threat to serious violence against persons or property. And Justice Mosley noted that the head of CSIS did not believe that the definition was met. The only specific example of threats of serious violence, as I said previously, were provided through weapons uncovered at Coots, but that situation was already dealt with by the RCMP using the criminal code before any of the extraordinary measures were created. And I wrap up by saying this, Chair. I think it's important that Canadians recognize that this government, although many Canadians felt the same way, had extended beyond lawful authority. They can't change the law to suit their own purpose. That's convenient for them. And, finally now a federal court has ruled that they did, in fact, extend beyond the confines of the law, and they did, in fact, breach the Charter. So I think it behooves this committee to look at this issue or come to some agreement on how it be best dealt with moving forward. And with that, Chair, I will acquiesce the floor to the next speaker.
Thank you, Mr. Motz. I have Ms. O'Connell next on the speakers list.
Thank you, Mr. Chair. I move that we adjourn debate.
Okay, I would like to recorded division, Ms. O'Connell?
Yes.
I'd ask the clerk to take a recorded division, please.
Ms. O'Connell.
Yes.
Mr. Biddle.
Yes.
Mr. McKinnon.
Yes.
Mr. Gaillard.
Yes.
Monsieur Chiffrier.
Oui.
Mr. Lloyd.
No.
Mr. Motz.
No.
Mr. Brock.
No.
Madame Michaud.
En faveur.
3.
Ms. Michaud.
En faveur.
Monsieur Julien.
No.
Sorry, I haven't heard, so my apologies. Mr. Julien.
No.
No. So defeated, 7 against 3.
Okay. Both your motions defeated. That motion's defeated.
The motion is,
Yeah,
is
that motion's
granted.
bad.
Sorry, my apologies.
Okay, so we will move on with, I believe, Mr. McKinnon is first. We'll get back to the
Thank you, Mr. Chair.
C-26, and you can start with 6 minutes of
you.
questions.
I'd like to welcome our witnesses here and thank you for being here and for all the time and effort you've put into this bill so far. I'm going to start with Mr. Traore and Ms. Proctor. You indicated that this legislation should align with international standards. Is there a specific international standard that you can specify?
Thank you, Mr. McKinnon. I appreciate the question. And there are a number of international standards that we would rely upon. And if I dare say, I would look forward to and I would welcome the opportunity to share with you what those international standards are during a more working session. For this debate and this discussion right now, the points that I would draw out were certainly the definitions and the response times and the punitive nature of the responses. So the 72-hour on a specific incident being responded, but a set severity of an incident would be a particular item of interest. And then the punitive aspects of the punishment of the infractions. Against an individual is a stretch too far that I've not seen any other international regulations go towards. But towards corporations, and the accrual aspect is equally further.
So do these comments pertain to the international standards, or are they part of your other, I mean, you mentioned them already. Is this a matter of adhering to those standards to clarify those definitions and clarify those obligations?
Sir, can you repeat the question, Mr. McKenna?
Well, at some point we'll have to submit amendments to this bill, and you indicated that we should adhere to international standards. It'd be helpful if we had specific standards that we should adhere to. And I guess, are those standards sufficiently encompassing, or do they go too far? And if you could clarify both of those aspects, it would be helpful.
Perfect.
We'll
Thank you.
make sure to get back to you with proposed amendments and examples of what we see as frameworks that are achieved.
If I can
Your
add
concern
to
about
that.
definitions,
Yep.
would that be assuaged with adherence to these standards?
If I can clarify as well, and apologies if during my opening statements I indicated otherwise, that adherence isn't necessarily the encouragement that we would be offering. It's more that a number of the aspects of C26 are far-reaching, much more far-reaching than established international standards for mature cybersecurity regimes of our allies in particular. So not necessarily adherence to them, more recognition that we don't need to necessarily go beyond what they're already working towards in their private and public partnership and enablement of the industry. So I hope that gives a little bit clarification that it's not necessarily alignment to international standards. It's not going further than as we try to work together to bolster our critical infrastructure.
So these standards basically establish a border within which we ought to operate.
That's a good way to put it.
Okay.
Thank you.
So can we clarify, I guess, and I'll open this to everyone, what are the risks we leave ourselves open to if this legislation does not pass? Go ahead, Mr. Shipley.
I draw your attention to April 2023, when a Russian-linked hacking group successfully penetrated a Canadian natural gas pipeline provider and was, quote, able to increase valve pressure, disable alarms, and make emergency shutdowns. And by the way, this Russian hacking team wasn't even their best. So that's what we're risking when we fiddle while Rome burns on cyber legislation. I'm not saying we're going to have a Hollywood-esque total society shutdown. I'm saying people could get killed. I'm saying businesses economically could be negatively impacted. I'm saying there are people that want to throw a punch and hit us right in the nose, and we are sticking our face up without our ability to defend ourselves, and it's going to hurt.
So how would this legislation stop that kind of attack?
So first, we got to walk before we can run. And let me put this into very clear terms. Canada's not even crawling when it comes to defending ourselves. You want to look at a leader right now? Look at Australia. We are lagging, and it's not going to be business that pays the price. It's going to be everyday Canadians. Every time there's a cyber incident, it contributes to the cost of living crisis in this country. So we need to get moving on this, and we need to get it right. And the flaws in this legislation that have been pointed out, they're significant. They will set us back. And so instead of making things better, we're going to make it worse.
Okay. I'm not sure how much time I have left, but can we go to
You have
Ms.
just a little bit over a minute.
We'll transfer to Ms. Bargadalia. Sorry. And if you'd like to weigh in on these questions as well.
Most certainly, Mr. Shipley started with one example, but if you think about the cyber incidents and threats, I don't think we can even keep up with any records and reporting in terms of how many there are a day. I'm just also thinking of the MP O'Connell, you mentioned Atlantic Canada, the Newfoundland health care infrastructure that was as well impacted. And what it is, it's a snowball effect. So if one portion of a critical infrastructure gets impacted, it impacts our economy, the society, and it really also impacts how foreign direct investment will happen in the future. How do foreign entities see us? Do they want to settle in Canada? Do they want to build a future here as businesses and as communities and as talent? So I see it as a two-way. While we have the trouble in front of our own door within the country, it is also on a global level, how do we get perceived and best align ourselves and ensure that we are actually, this is the Cyber Right Now tagline, lead the global cybersecurity future and be the most secure country on the planet. Canada can be that, and I think C26 is a step forward, but I think we need to speed it up a little, as it has been already in discussion for quite some time. Thank you.
Proceeds at its own pace. I'm sorry, I'm thinking I'm out of time, so maybe you can shoehorn an answer in for someone else. Well, thank you. Or maybe continue until we get shut down.
I'm sorry, the clerk and I were just having a little sidebar. Sorry, Mr. McKinnon. Ms. Michaud, you're up next for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. Thank you, dear witnesses, for being here, and also thank you for your patience. Ms. Proctor, Mr. Traoré, you mentioned three important elements about this legislation. Mr. McKinnon talked about the need for aligning with the international standards, and I would like to know more about that. I think that that would require a longer discussion, but you also talked about clarifying the definitions in the bill, and because there's a lot of space given to regulation, according to what I've understood, there's a lot of power given to the Minister of Industry, to the Government and Council to pronounce orders. And so when we read the bill in its current form, it could go in all directions. It grants a lot of powers, but we don't know exactly what the ministers might invoke, what they might ask, or what they might insist that businesses do. So I imagine that clarifying some definitions would help to structure, to limit the actions of the government after. I'd like to hear more about that. There are two aspects to your question. The first is to really being able to implement the regulatory framework and the Act. We all want to be able to implement this Act and do it the best way possible. We think that some definitions do leave a lot of room for interpretation. And we're talking about a very important subject. We would like a clearer framework so that we can understand better. So we see terms such as major incident or cybersecurity. These are quite broad terms. It limits us, and we think it would be simpler if we were able to specify the meanings rather than waiting for regulations to present various possibilities of definitions, and it will be a Pandora's box. It's easier to clarify things right from the beginning. And the second point is related to government intervention. So we would like that the essence of this does happen. The breaches in cybersecurity are huge, and the cost at IBM is $7 million per company, and it can be $12 million for the financial sector. So it's important to act. It's important that the government take leadership in this matter, but the government's action has to be codified and foreseeable for the various actors in the system. Mr. Shipley, you talk about creating positive reasons to so that businesses could help with the framework for cybersecurity so the government can force businesses to do this. And there would be punitive financial sanctions. And last week, we were thinking that there should be fiscal incentives. And so instead of having monetary penalties, we would do financial incentives, but keep the sanctions if businesses don't comply. So also some businesses are thinking that it creates a lot of paperwork. So it's not a will of not complying, but it creates delays, and it asks businesses to do a fair amount of work. You've consulted businesses, I imagine. What do they tell you? Would a financial incentive be of interest to them, for example? Thank you for your question. I'm sorry, excuse me for my French.
The due diligence defense to the administrative monetary penalties is the first thing that becomes a positive thing. So if I showed that we were in the spirit trying to defend our organization and we were doing what we should, that's a positive step. That encourages me to invest so I can show that. So that's why it's so important that this get addressed in the Telecommunications Act. To be very clear, the Canadian private sector already spends $9 billion a year on cybersecurity. So we're not coming to Parliament looking for a handout for government to solve all problems. But what's interesting, this legislation deals specifically with very large enterprises and critical infrastructure. It does not deal with 98% of Canadian businesses, which are small businesses, 50% of which spend nothing on cybersecurity today. So they absolutely need help. You know, as parliamentarians, you've heard the story of the impact of COVID-19 on small businesses, the debt load, and more. They cannot afford yet another thing. And let's be very clear. The bill for cybersecurity on small businesses and large enterprises is because at a national level, we fail to protect them from other countries and from criminals. So yes, I highly encourage other measures. But my point on the speed of which we need to move in this legislation is this is just the first step of laws you need to consider, and we need to get it right. But I'll be honest, where Canadians are being hurt, and hurt badly right now, is in healthcare. You have 5 hospitals in Ontario right now that are still recovering from a ransomware attack. We still don't know what happened in Newfoundland and why it happened, nor learn from it. And we know from a non-peer-reviewed research study in the U.S.
Ask you to wrap it up, please.
that 40 to 60 Americans have died because of ransomware attacks against hospitals there. So yes, we need help. We need to get this law done first, and the first thing to make it better from a positive side is to have a due diligence defense.
Thank you, Ms. Michaud. Thank you, Mr. Shipley. Mr. Julian, you have 6 minutes.
Thanks very much, Mr. Chair. I'd like to start with Mr. Shipley and Ms. Bargadalia. We have had this legislation basically sitting now for 20 months. It was introduced in June of 2022. We're coming up to the 2nd-year anniversary, and we're only beginning, really, the hearings about the legislation. How important is it that we move forward quickly on this, given the problems that all our witnesses have enumerated? And what would you suggest in terms of a time frame, given the length of time it's taken to get the bill this far?
Thank you. I'll go first. Thank you for your question, Mr. Julian. In the time that we have languished, Australia has published a comprehensive cyber strategy in relation to some horrific attacks on their citizens and their personal medical information. Europe has moved forward with legislation. The United States has moved forward with bold executive and legislative action. And we are the easy target left in the West. So we are going to continue to attract an unhealthy amount of attention that is going to steal prosperity from Canadians and risk safety so soon, because the reality is this. We'll get this legislation passed, and then we're going to end up in at least a year, if 2 years, of battling over regulation. And that particularly goes back to Ms. Proctor's point about the importance of getting the definitions as clear as possible in legislation so we can get moving on this stuff. We are way behind. And I know Parliament has many issues in front of it, but we live in a digital world, and we're acting like we're in the 20th century.
Before I go to Ms. Bargadalia, would it be fair to assume that given the fact that other countries have moved forward, that the longer we delay, getting this bill right and getting it back to the House and then to the Senate, the more likely it is to have serious incidences because we have that vulnerability?
Absolutely.
Yeah, thank you. Ms. Bargadalia, on the same question, how critical is it for us to act?
It is very critical, so that's a definite yes, that it is, we should act in a timely manner. But what I would like to emphasize is we also need to get it right, not to rush through it in a way that so I'm a little hesitant to name a time frame because the focus should be on all the challenges we pointed out and for us to address these properly. But comments were made as well on national cybersecurity strategies and plans in other countries and so forth. And we don't have our national cybersecurity strategy yet launched. We greatly look forward to it. The Canadian Chamber has fed also into the submission because for me and for our members, it would provide the broader overarching picture of cybersecurity per se, and Bill C-26 would be one part of that strategy. So we see it's a holistic view and a comprehensive approach there. Lastly, and there was one comment I wanted to make in terms of time, and I lost my train of thought there. You had another follow-up question, I think, to Mr. Shipley. Could you please remind me what that was?
Just the vulnerability that this creates with Canada not moving forward and other countries putting in place legislation.
Actually, yes, I wanted to make one more point that members had mentioned to me. We had this experience with another bill where when we wait too long, provinces might go ahead and start their own legislation. And a few members have mentioned that there is a concern that while we are internationally lagging and maybe also not harmonizing right now in many ways, that this could happen on a domestic or provincial level as well. And a patchwork is always working to the disadvantage of businesses.
Thank you for that, Ms. Proctor. Mr. Traoré. You've spoken about the issue of regulation and also having in place a reporting period that is less onerous. Is getting the legislation right, responding on those two areas? And I would ask all the witnesses whether you have specific amendments to offer that would take improvements to the bill out of the regulatory format and put it into discussions that we can have around this table and adoption in Parliament.
Thank you for the question. And if I start a little bit, to bring both of your questions together, wherein you were asking the risk of not acting. In IBM, we partner with, and I strategically advise with over 1,700 organizations. Admittedly, they're not all in direct scope of this, but they would be impacted through the passing of Bill C-26. Many of those organizations struggle. Many of those organizations are focused on Canada. Many of them are focused on multinational. By not acting within Canada, we are, by effect, encouraging those organizations to pause on Canada. We don't have the regulations, we don't have the definitions, we don't have the laws in place for them to understand the arena that they're playing with within Canada. This bill languishing is causing that pause to get larger. It also, from a collective individual perspective, shifts into the mindset of our resources, of our teams, of our neighbors. Our graduates, our children coming up through education, they challenge what is Canada's position on cyber risk, cyber security. Not just for the critical infrastructure that we need to run and operate, but for the employment opportunities that we have and our organizations have.
Thank you.
So I hope that gives you a bit more of a perspective on that. So then when we lean into the reporting time period, it equally speaks to the risk that one of the best things
Proctor,
that we do.
I'm going to have to ask you to wrap that up. We're out of time. Sorry, I thought you heard me. Committee, we have the room resources till 6 p.m. So I'm going to give everybody one more. I think this is some very interesting information coming out here. So,
point of order?
Yes, sir.
I'd like to suggest, rather than do that we go to the next panel. I thought, I may have misunderstood.
You were reading my mind.
Okay.
I was going to give them 2 minutes to each side.
I was going to just, 2 minutes for each party is 8 minutes. We're going to be cutting into the time for the next panel. I'd love to hear more from these guys, but we
What-
also need to hear from the next panel, too.
Okay, maybe someone wants to put forward a UC motion, Mr. Julian. I don't know what the will of the. And again, talk like this, we're wasting time.
No,
to do this.
Mr. Chair, I actually thought your suggestion was a good one. If you're doing one more round for 2 or 3 minutes to each party, I think that makes sense.
Okay, we don't have a UC on that, so we'll make it very quick. I will hold everybody to 2. If you want to pass your time and we can move on, that's up to everybody too. So 2 minutes, starting with Mr. Lloyd.
Well, thank you, Mr. Chair, and I'd like to start by offering my thoughts and prayers and hopefully the committee's for His Majesty the King of Canada, King Charles III, as terrible news about his cancer, and I know our thoughts are with his family, and also to the families in Atlantic Canada, including, I believe, our chair, who are undergoing a massive snowfall right now. So just wanted to share, our committee's thoughts and prayers with those families. I also want to put a motion on notice, Chair. I'm not going to be moving the notice or the motion, but I want to put on notice a motion regarding car thefts. As we know, in the past 8 years, car thefts have exploded in this country, and particularly in the last 3 years, we've seen a massive explosion in the amount of insurance premiums or insurance claims that have been paid out in 2022.
Point of order, Mr. Chair. Point of order, Mr. Chair. I can't understand. I don't know why the Conservative Party wants to file a motion on car theft at the Public Safety Committee when the committee already had a motion about car theft that I filed a few weeks ago, and we are supposed to be studying this topic in a few weeks after the study of Bill C-26. So I'm wondering about the need to file a new motion on this same topic.
Mr. Lloyd does have 2 minutes on the floor. He'd probably be done by now, but it is in order, so I'll have to let Mr. Lloyd proceed.
On the same point of order, I would observe that we just like 2 meetings back had a debate on a car theft motion as well. So it seems excessive and redundant to me.
But it is in order, so Mr. Lloyd, go ahead.
Well, thank you, Mr. Chair. And seeing as I have a minute left, there's been an explosion in car theft, especially in the last 3 years. And my notice of motion will be calling on the government to take immediate action. Is there another point of order?
Go ahead, Mr. Julian.
Yeah, Mr. Chair, I'm quite disturbed by this. We have a good faith move to do a final round of questions. I've got a ton of questions for the witnesses. Conservatives are spending their entire opposition day tomorrow on auto theft. And as Madame Michaud has already mentioned, she's already brought a motion through that has been adopted by this committee. So I don't see this as a legitimate motion being brought forward in good faith. I see this as a filibuster tactic, which I do not believe is appropriate, given that we have witnesses who've spent their time and Canadian taxpayers who've spent their resources to have these hearings about legislation that we've just heard is absolutely critical to adopt. So I don't believe it's appropriate. It's redundant to bring forward this motion at this time. And if the member persists in trying to filibuster this committee, I will have to challenge your decision to allow the motion to come forward.
Thank you, Mr. Julian. I don't believe, I'm going to take Mr. Lloyd in good faith. He said he's only got 30 seconds left. That's not filibustering. He had 2 minutes. It was his time. Quite frankly, we have spent more time outside of that discussing it. So, Mr. Lloyd, I'm going to hold you to your word, and we'll wrap this up.
Well, thank you, Mr. Chair. And I'm just disturbed that I've been blocked so many times from bringing forward this common sense motion. This is an immediate problem. I've had my vehicle stolen. It was attempted to be stolen. I stopped a vehicle theft in Alberta over the Christmas break that occurred right in front of my house. And this is an immediate problem. These repeat offenders need to be held accountable. We can have a study on this, but Canadians want action now. We need to get tough on these repeat offenders. This is costing every Canadian family $500 a year in increased insurance premiums. And I'm just appalled that I've been stopped so many times from bringing forward a common sense motion so that we can debate this in the House and take real action on this issue. Thank you, Mr. Chair.
Thank you, Mr. Lloyd. We'll go to Ms. O'Connell for 2 minutes.
Thank you, Mr. Chair. Once again, it's the fake outrage for the Conservatives while the cameras are rolling. Actually, once we get through C-26, auto theft is the very next study that Madame Michaud had brought forward that we would actually be dealing with. And I also find it incredibly ironic that it's my time.
As a point of order, just as every head when he was speaking. Go ahead, Mr.
We have
Lloyd.
witnesses here. I think it's very important we hear from them, Mr. Chair. Thank you.
Yeah,
Ms. O'Connell, the floor is yours
thanks.
still. You have a
I'm
minute and a
actually
half
really
left.
pleased that my colleague just did that, because it just goes to show the immaturity that the Conservatives are showing. For every day that we have been studying C-26, they haven't asked a single question. Mr. Brock, I overheard him after his filibuster the other day, said, "What are we studying here? Is this the first day we're on it?" They don't care about security or safety.
Point of order.
Point of order. Go ahead, Mr. Brock.
I didn't comment at all at the last meeting. I don't know what Ms. O'Connell was talking about.
Thank you.
No, I overheard.
The record
Thank
will
you.
show.
Sure. Let the record show, Mr. Prosecutor, that I overheard you speaking to Mr. Lloyd about not knowing what was
Point of
being
order, Mr. Chair.
discussed.
And I heard
order,
all
Mr. Mayor.
kinds of backroom chat between Ms. O'Connell, Mr. Biddle, their team. If we
Sure.
want to talk about dirty laundry, let's get it all out on the table.
Thank you. I'm not sure that's a point of order. Go ahead, Ms. O'Connell.
Point of order. I just
Folks,
want to
I'm
know.
going to speak up here for a minute. Everybody's complaining we're not having enough time. We are wasting more time on points of orders.
I understand.
I have the
However,
floor right
points
now.
of orders
Mr.
need to be
McKinnon,
done.
Mr. McKinnon, the chair is speaking right now, so
Sorry.
I'll address you in a moment. Thank you. So, folks, if we do want to wrap this up, we've got the time stalled right now. Ms. O'Connell, you have just over a minute left, and we could proceed. But, Mr. McKinnon, you do have a point of order. Go ahead.
I was just wondering which of our four Conservative colleagues are members of this committee and which are substitutes, and whether, I would ask a clarification as whether people who are not members of this committee can move points of order.
Right now, the clerk has informed me that Mr. Lloyd is in this committee today, Mr. Motz is in it, Mr. Brock is in it.
Thank you, Mr. Chair. So once again, the Conservatives talk tough on crime, and Mr. Brock can raise whatever supposed conversations he claims to hear, because I guarantee it didn't exist, but I heard him talk about not even knowing what committee he was coming into filibuster or what issues it was on. And I think it's been demonstrated very clearly the fact that the Conservatives had time to ask questions and didn't bother. So moving to the witnesses on C-26, Mr. Shipley, you talked about the importance of this legislation, and you raised examples of natural gas pipeline with a hack and what it does for critical infrastructure, including workers who might work in the energy industry. What happens if Canada is not prepared for a cyber attack in our energy industry?
We got lucky with this last attack. That's everything that I've been told publicly about. And we only know about this attack because of an American soldier leaked it.
Mr.
Otherwise,
Shipley,
the
I'll
Canadian
have to ask
public
you to
wouldn't know
wrap
about
this
it.
up quickly, please. I said I was going to keep it tight to 2 minutes. Go ahead.
But I do want to get to something that was raised about cars. Modern cars right now are software. The reason they're being stolen so easily is they're easily hackable. But if you want to talk about something that should keep you awake at night, is the fact that Elon Musk, Tesla, does over-the-air updates, and every single Tesla in this country could get bricked, and there's not a law in the books holding them accountable to this country, either for the cybersecurity of it to prevent theft, or more broadly, to prevent the actual cause of major accidents.
Thank
We need
you,
to
Mr.
move.
Shipley.
Thank you.
I hate to cut you off, but we are very tight on time. So, Ms. Michaud. Ms. Michaud, 2 minutes, please.
Thank you, Mr. Chair. Ms. Bargadelia, earlier you mentioned a 72-hour timeline so that the businesses can signal incident to the government. In the bill, immediately is mentioned to report as soon as the incident happens. You talked about giving the businesses time to do this, which could make it easier for businesses. Being from the Chamber of Commerce, I imagine you've heard from businesses. I think it would be good to give them a bit more time. I was talking about the additional paperwork that it represents for them. What are you hearing from businesses? And what are the arguments justifying giving them 72 hours to report?
Thank you for the question. First of all, when an attack happens, you need time to figure out the nature of the attack, the scope, and that can't happen immediately. So it's actually from the time, the 72 hours, members were also looking at from the time you become aware of it, those 72 hours. And it is based on recommendations by the United States, by their Cyber Incident Reporting for Critical Infrastructure Act, which is from 2022, and CIRCIA. So it has been in practice, and we like to learn from those that have actually applied best practices. So therefore, I hope this answers your question.
Ça répond. Merci beaucoup. Il me reste.
Yes, it does answer. I have a few seconds left, Mr. Shipley. Earlier, you gave the example of Australia, and IBM also mentioned of international standards. Do you have examples of countries where we could go look at their cybersecurity legislation? Because, yes, we all agree that there's a bit of delay in Canada.
The witnesses could supply that answer in writing or contact Ms. Michaud after. Mr. Julian, 2 minutes. Thank you.
Mais là, je vais continuer ces questions-là.
So I'll continue with this question. So the best countries, as examples, what are the models that we need to look at? And secondly, I'll start with Mr. Traoré. It's a question of protecting the confidential information that businesses have. How important is it to protect that in the framework of the bill? It's extremely important. On several levels, we can talk about the socio-economic aspect. We know the value and the importance of data, and we want to protect these data. We don't want them to fall into unauthorized hands. So, yes, that's something that we say that it's that way for businesses in Canada. It's something that's highly important. Thank you very much.
And what are the best countries in terms of what models we should be looking to?
Great question. So there are a number of countries that we can emulate based on some of their response to various activities. Being mindful that cyber is a global issue. So while there are jurisdictions within individual countries, many of the corporations that are headquartered and operate out of Canada certainly are multinational. So I think it's great to be looking at additional countries from Canada. All of our Five Eyes allies, I would encourage you to start with.
Thank you.
Thank you.
Ms.
Okay, there it is. Well, I can only echo those sentiments because everything pretty much has been pointed out and said in that regard. And I always like to remind everybody as well, though, to put it also into a Canadian context while looking for alignment and harmonization with other jurisdictions. Thank you.
Mr. Shipley?
Our business is with the United States in terms of the amount of trade we do. We best make sure we're aligned with our largest trading partner.
Thank you, Mr. Shipley. We are out of time. Thank you to the witnesses. Thank you for enduring today. And we will take a short, folks, we are limited on time. Let's take a short 5-minute recess and we'll get set up for the second part. Thank you, everyone.
Mr. Chair, I apologize for speaking over you earlier.
And just want to remind everybody, we do have resources till 6, but I also want to mention that clock is not the clock we go by. As Mr. McKinnon would know, it's never accurate. It's 5:24 right now, but we do have a hard stop at 6. So we do have about 35 minutes. So up first, thank you to the witnesses for being here today. We have from Bruce Power, Todd Warnell, the Chief Information Security Officer. From Citizen Lab, we have Kate Robinson, the Senior Research Associate, Monk School of Global Affairs and Public Policy, University of Toronto. And by video conference, we have from Open Media, Matthew Hatfield, Executive Director. So thank you to all for being here. We'll give you 5 minutes each, and we'll start with Mr. Warnell.
All right, thank you, Mr. Chair and members of the committee. My name is Todd Warnell, and I am the Chief Information Security Officer at Bruce Power. Established in 2001, Bruce Power is Canada's only private sector nuclear generator, annually producing about 1/3 of Ontario's power, and life-saving medical isotopes used around the globe to fight cancer and sterilize medical equipment. I'm grateful for the invitation to participate in your review of Bill C-26. Today, I will focus my comments on Part 2 of the Act, namely the Critical Cyber Systems Protection Act. I'm here before the committee to provide a perspective that proceeding with the implementation of Bill C-26 is of vital importance to the safety and security of all Canadians. Canada has prospered over the last 4 decades through a period of relatively stable and predictable global relations. However, that period of stability and predictability is changing amidst a backdrop of global geopolitical tensions and changing global dynamics. Ensuring the safe and reliable delivery of critical services that Canadians depend upon every day is not and cannot be a political issue. Within Canada's nuclear industry, we have seen and demonstrated that through collaboration with governments, regulators, industry, academia, and individual Canadians, we can be successful in establishing and regulating cyber systems that are important to the safe and reliable operation of critical services. The Critical Cyber Systems Protection Act will introduce a broad framework from which all critical sectors, in collaboration with government and regulators, can develop and implement risk-informed and performance-based regulation to enhance the reliability and resilience of critical services. Committee should consider ways of ensuring appropriate checks and balances are in place for any directives issued to address a risk or threat to Canada's critical cyber systems. Harmonizing Canada's cybersecurity framework across critical sectors through Bill C-26 will also align our approach with our closest allies and avoid being left behind as our allies move forward with enhancing their respective national cyber resilience programs and driving innovation that can enhance our collective capabilities in protecting, detecting, and responding to a changing threat landscape. In conjunction with Bill C-26, we urge lawmakers to review and consider the amendments to the CSIS Act to enable Canada's intelligence community to exchange and cooperate on cyber threat intelligence with Canada's public and private sector operators in both a proactive and preventative manner. Thank you for the opportunity to address the committee today, and I look forward to your questions.
Thank you, Mr. Warnell. Up next, we have Ms. Robertson, please.
Good afternoon. My name is Kate Robertson. I am a researcher at the Citizen Lab, which is based at the University of Toronto's Monk School. My comments today draw on Citizen Lab's research on cybersecurity and telecommunications policy, data security, and transparency and accountability mechanisms that are applicable to the relationship between governments and telecommunications providers. My brief that was submitted to this committee, written with Lena Lee of McGill Law, provides a charter analysis of Bill C-26. Part 3 of our brief sets out our recommended amendments, building on a report on Bill C-26 written by my former colleague, Dr. Christopher Parsons. There are key recommended amendments that would act as constitutional safeguards in the legislation, and this is not to state that they're exhaustively read here. To protect the rule of law and free expression, orders issued under the legislation must be published in the Canadian Gazette. Any exceptional circumstances that might justify confidentiality of those orders should be expressly and strictly defined in the legislation and should be time limited. For privacy rights, the legislation needs explicit protections for personal information, notice requirements, and tighter controls surrounding the sharing and use of personal and confidential information. You'll find proposed terms for those amendments under our recommendations in our brief 13, 14, 16, 19, 28, and 29. We also reiterate, as others have, that orders issued must be proportionate and reasonable. In particular, the legislation should make explicit that an order compelling the adoption of particular standards cannot be used to compromise the integrity of a telecommunications service, such as by compromising encryption standards. And the terms for those recommendations are in 1 and 5 of our brief. It is notable that these amendments are compatible with the government's objective to play an assertive role in protecting Canada's networks. This is not a tug of war between competing public interests. This is important because the courts do not tend to find it reasonable if constitutional rights are infringed in a way that is unnecessary. The desire for expediency through Parliament is understandable, but if these issues aren't fixed now by legislators, then the legislation may well be held up in court litigation for years that ultimately requires additional legislative time to fix. Amendments to limit secrecy and to require proportionality also reinforce the government's objective of protecting our networks. I agree when it was said last week that cybersecurity is a team sport, and I agree with Mr. Warnell's comments on the same subject. Effective cybersecurity integrates expertise from across a range of sources, including regulators, industry, civil society, academic and security researchers, and data journalists. Dr. Parsons' report on C26 last year, and this committee process itself illustrates how industry and independent expertise can provide a path forward for improving good legislation without detracting from the bill's core mandate. Public transparency will be an effective way to garner expertise from these sources as the legislation is implemented over time. Citizen Lab's recent report, Finding You, which is Appendix C to our brief, underscores how secrecy at the regulatory level has led to serious geolocation-related threats associated with contemporary networks. The report documents persistent vulnerabilities at the heart of the world's mobile communications networks. And it notes that the failure of effective regulation, accountability, and transparency has been a boon for network-based geolocation surveillance. In other words, when network standards and regulations are shrouded in unnecessary secrecy, it enables network insecurity to fester. Similarly, without proportionality and transparency, Bill C-26, unamended, could enable successive governments to actually undermine network security and ultimately human security through orders that would drill holes in encryption standards in telecommunications networks.
Ms. Robertson, can I ask you just to wrap this up? Your time's up. Or do you have much more to go, or are you just about done?
My clock is slower than yours. I had 20 seconds, but I will leave the remainder of my comments for questions.
Sorry about that. Thank you. And thank you for that. And up next, we have Mr. Hatfield by video conference.
Hi there. I'm Matt Hatfield, and I'm Executive Director of Open Media, a grassroots community of 230,000 people in Canada that work together for an open, accessible, and surveillance-free internet. I'm joining you from the unceded territory of the Stolo, Tsleil-Waututh, Squamish, and Musqueam nations. So I'd like to ask us all a question. What does cybersecurity mean to you as an individual, as a family member, and as a citizen? For me and for many people across Canada, our cybersecurity is inseparable from our privacy. So much of our everyday lives are connected online, much more so since COVID. And none of us feel secure with the thought of being spied on in our everyday lives, whether by hackers, hostile states, or by our own government. For most Canadians, our cybersecurity is very much about that sense of personal security. The drafted Bill C-26 you have in front of you threatens that security. It poses enormous risks to our personal privacy, without basic accountability and oversight to ensure the people given these powers don't abuse them against us. You must fix this. Exhibit A is Section 15.2 of the Telecommunications Act, which grants the government the power to order telcos to do anything or refrain from doing anything. There's no limits here. No tests for necessity, proportionality, and reasonableness, no requirement for consultation. The government could use these powers to order telcos to break the encryption we need to keep ourselves safe from hackers, fraudsters, and thieves. They could even use these powers to disconnect ordinary people indefinitely from the internet, maybe because our smart toaster or an old phone we gave our kids gets hijacked by a hostile botnet. Without a requirement that these orders be proportional or time limited, these are real risks. It gets worse. The government would be allowed to keep even the existence of these orders, never mind their content, top secret indefinitely. And even if these orders are challenged by judicial review, the minister could bring secret evidence before secret hearings, flying in the face of basic judicial transparency. There's no excuse for this. Our close allies in Australia and the UK have shown how cybersecurity can be strengthened without compromising fundamental rights. Why do Canadians deserve lesser protections? And all of this comes when Parliament is working on strengthening our privacy laws through Bill C-27. You have to ask, does one hand of our government even know what the other is working on? We recognize that there are very real problems, though, that C-26 is trying to solve. When we read the government's stated objectives, we're on board. Protecting digital infrastructure? Sure. Removing risky equipment from hostile states? Of course. Forcing big banks and telcos to better protect their customers? Of course. But we can fulfill these objectives without sacrificing our rights or balanced effective governance. Let's talk about how. First, the government's new powers must be constrained. Robust necessity, proportionality, and reasonableness tests are an absolute must. An unbreakable encryption is the fundamental baseline that all of our personal privacy depends on, so there must be an absolute prohibition on the government using these powers to break encryption. Second, privacy rights must be entrenched. Personal information must be clearly defined as confidential and forbidden from being shared with foreign states who are not subject to C-26's checks and balances. Third, the government must not be allowed to conceal use of its new powers under a permanent veil of secrecy. Fourth, when the use of these powers is challenged in court, there must be no secret evidence. Special advocates should be appointed to ensure all evidence is duly tested. And fifth, any information the Canadian security establishment obtains about Canadians under C-26 should be used exclusively for the defensive cybersecurity part of their mandate. I hope you all remember that NCIRA, the body explicitly established by Parliament to oversee CSE, has complained for years about CSE not being accountable to them. Knowing how difficult it's proved to keep them accountable on their existing powers, please don't grant them broad new powers without tight, clear use and reporting mechanisms. Like people have said, when cybersecurity works, it's a team sport. It requires buy-in from all of us. We all have to be on Team Canada, and we all have to trust in the regulatory framework that governs it. There's zero chance of that happening with Bill 26 as is. Adequate transparency, proportionality, and independent verification are the necessary baseline that this bill has to earn for it to work. We're going to be delivering a petition of nearly 10,000 Canadians to you shortly, of folk who are calling for that baseline protection. And we urge you to listen to these voters and adopt the amendments package which civil society has suggested to you to get this legislation where it needs to be. Thanks, and I look forward to your questions.
Thank you. Thank you to all the witnesses. We will start for 6 minutes with Mr. Lloyd.
Thank you, Mr. Chair, and thank you to all the witnesses for being here today. I think my line of questioning will be mostly to yourself, Ms. Robertson, and yourself, Mr. Hatfield. Very concerned with the testimony you've shared with me today, and also in light of the fact that, the government certainly has been a victim of hacking itself. I recall Global Affairs was the victim of a recent hack, and I think this is one of the sort of dilemmas of increasing centralization of information like C-26 purports to do in collecting information on the cybersecurity plans of the designated operators. Is there any guarantee or is there a risk that when government collects all of this very confidential and powerful information that the government is better equipped than some of the best companies in the world to protect that information from hackers?
The amassing of data in any database brings with it attendant security risks. The extent of them I cannot comment on, but I would indicate that your concerns are connected to amendments that we have raised in our brief regarding the handling of data. Right now, the information sharing powers within the Canadian government that would be enabled by Bill C-26 if passed unamended is extremely broad. One of the limits, for example, that we've recommended is that the use of the information being shared should be constrained to cybersecurity objectives and not piggybacked objectives objectives that are layered on after the fact, and that retention limits are strictly defined to address the very concern that you're raising. In that way, while there is understandably a need for some examination of critical information to enable that mandate to be fulfilled, it should be very strictly defined within the legislation itself.
And Mr. Hatfield, did you have comments on that?
Yeah, I think I would reinforce what Ms. Robertson said. I think transparency is actually the ally of effective cybersecurity. A lot of mistakes get made when things are stored in the dark. But rather than allowing our security establishments sort of hoover up the maximum possible amount of information and sit on all of it, I think putting some limits in terms of retaining only information that is strictly necessary and deleting other information at a certain point helps minimize the risk of that information transfer.
Are you confident that the legislation as written coming before this committee, unamended, will protect the privacy of Canadians and the safety of our cybersecurity sector?
Unamended, I think this legislation makes our privacy much worse, actually.
Much worse. And that's very concerning. And of course, what sort of, you've listed some amendments that you've put forward. What do you think would be the most powerful amendments to ensure that, Canadians' privacy rights, but also the security of all this information that the government's purporting to gather is protected?
I'll continue, but then I want to pass it over to Ms. Robertson. I think the necessity proportionality tests that we've applied are a really important piece here to make sure that information is being collected only for appropriate purposes. I think getting those kind of fixes, similar to what Australia has done, will greatly mitigate some of the potential harms of the legislation.
Thank you, Mr. Hatfield. Ms. Robertson.
Ultimately, under the Constitution, the courts look to an effective mechanism of accountability and review. And so in this case, it's hard to pinpoint one particular amendment when what the courts look for when protecting privacy is an interlocking system that enables effective review. And I've identified in my remarks at the opening a number of amendments that would assist that review mechanism, not one of which could be functional on its own. For example, we've identified notice requirements as an important mechanism. This is a way to enable individuals whose personal and confidential information has been shared to even know that has happened, so that it could be effectively challenged in court. And that's just one example of the amendments that we've identified and report for that reason.
Mr. Hatfield, something you also said in your remarks greatly disturbed me. We've seen, in response to cybersecurity incidents, the government is putting forward legislation to give itself massive new powers. We have seen, in recent examples of government using legislative powers at its disposal to freeze people's bank accounts. And, I have deep concerns that, if we don't put in the necessary checks and balances that you are talking about, that we could be giving the government extraordinary powers to shut people out of the internet, which, as we know, is become so essential in the 21st century to participate in our democratic society, participate in our economy, to be connected with your loved ones, to work. And I have serious concerns, and so I just want to pass along that we share your concerns, and we'll be looking into this further. With my remaining time, Mr. Chair, I'd like to split my time with my colleague, Mr. Motz. Thank you, Mr. Chair.
Thank you, Chair. I know and my colleague, I know the committee is going to be annoyed, but Canadians are more annoyed with the fact that we have an issue of the Emergencies Act. It was spoken about before, and so I'd like to move the following motion, Chair, that in light of the recent federal court ruling, which found that the government's use of the Emergencies Act in February of 2022 to have been illegal, and that the special criminal laws subsequently created by the Liberal cabinet to have been an unconstitutional breach of
point of order.
Canadians' charter rights.
Mr. Motz, just one moment, please. We have a point of order. Mr. McKinnon, yes, sir.
Yes, at the outset seems to be pretty much exactly what Mr. Motz just moved. That motion was moved.
When he's let him finish, sir.
Was voted to adjourn the debate. I don't think there's enough time has passed since that has transpired. I think this is repetitive and redundant and should be out of order.
Thank you, Mr. McKinnon. I hadn't even read it yet, so I can't comment on that yet. Mr. Brock, did you have a comment?
Perhaps Mr. McKinnon can allow the member to actually read out the motion before he opines on it.
Yeah, we don't know how different it is. Mr. McKinnon. So go ahead, Mr. Motz.
Thank you. I continue on that the created by the Liberal Cabinet have been unconstitutional breach of Canadians' charter rights, and the committee undertake a study of 6 meetings pursuant to Standing Order 1082 of the Department of Justice's role in supporting the government's illegal and unconstitutional decisions concerning the Emergencies Act, together with the consequences which follow the court's decision, provided that A, the committee invite the following to appear separately as witnesses for at least 1 hour each. 1, the Honourable David Lametti, the Minister of Justice and Attorney General of Canada at the time. The Honourable Marco Mendocino, the Minister of Public Safety at the time. 3, the Honourable Arif Virani, the Minister of Justice and Attorney General of Canada. 4, the representatives of the Canadian Civil Liberties Association. And 5 representatives of the Canadian Constitution Foundation. And B, an order to issue for all legal opinions which the government relied upon in determining that 1, the threshold of threats to security of Canada is defined by Section 2 of the Canadian Security Intelligence Service Act, required by Section 16 of the Emergencies Act, had been met. 2, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. 3, the situation could not be effectively dealt with under any other law in Canada as required by Section 3 of the Emergencies Act. 4, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And 5, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that these documents shall be deposited with the clerk of the committee without redaction and in both official languages within 7 days of the adoption of this order.
Point of order.
As I've indicated before, Chair.
Mr. Motz, we have a point of order. Just a moment, please. Ms. O'Connell.
Now that we've heard the full motion, I would argue to Mr. McKinnon's point that even if it is a different motion that he's submitted, the only difference is the timing, and therefore it is too similar from a motion that we've already dealt with, and therefore should be out of order.
Thank you, Ms. O'Connell. If you just give us a moment, the clerk's trying to. Which was the motion? Is it 1 point what? Ms. O'Connell, I don't think we need snide remarks or comments at the table.
Know which motions you're moving.
I'm not moving anything. I'm the chair, and the clerk's looking it up because he doesn't know, Ms. O'Connell. So what's so funny?
I find it funny.
It's the one with the
Glad you. I didn't.
I'm allowed to laugh, or do you? I find it funny that you guys are that disorganized in your own
Are we
filibuster.
disorganized, or are you just trying to cover up?
Cover up what? You don't want to talk
order,
about
everybody.
cyber?
Order.
For the Canadian public on the
Mr.
Emergencies
Motz,
Act.
Ms.
Want
O'Connell.
me to read from
order,
your mayor?
Please.
I got.
Sure.
Order, please, Mr. Motz, Ms. O'Connell. Mr. Biddle, please. Everybody, it's been a long day. Let's have order, please. Mr. Biddle. Mr. Biddle, please. Can we have order? And the chuckles continue. That's good, I hope. So, Mr. Motz, it is the 1.2 is the...
I don't have that on mine, but yeah, it's the one with the study of 6 meetings.
So it's
1.2.
and your last one was
1.1.
and significantly different. You're asking for a different amount of meetings.
Yes.
Okay, I think they're significant enough. Carry on, Mr. Motz.
Point of order. Point of order. I challenge the chair,
Definite.
and I ask for a recorded division. Chair, before you start, can you please remind everybody that a no vote is, if I'm correct, a no vote means you don't sustain the chair's ruling?
I'll ask
Correct?
the clerk just to clarify. Clerk, could you please clarify?
So the motion is shall the decision of the chair be sustained.
And I ruled it was in order, so. A recorded vote, Mr. Clerk, please.
Ms. O'Connell,
No.
Mr. Biddle?
No.
Mr. McKinnon?
No.
Mr. Geir?
No.
Monsieur Chiffquet?
No.
Mr. Lloyd?
Yes.
Mr. Motz?
Yes.
Mr. Brock?
Yes.
Madame Michaud?
Contre.
Monsieur Julien?
No, contre.
7-3.
Point of order, Mr. Chair.
7-3. You have to sit down.
The motion, or your motion passed, so mine ruling failed. Mr. Julian?
Thank you, Mr. Chair. We only have 11 minutes left. I know it's a hard stop at 6, certainly a hard stop for most members. I would suggest if we could just divide for the three parties that haven't yet had questions, perhaps 9 minutes each. 3 minutes each to make the...
So that's what we're going back to that, right?
That's how you can proceed anything.
Okay, yeah, I have 10 minutes left. I have 5:50, so we'll do 5 minutes left for each. Is that fair, Mr. Julian?
Well, that takes us to 6:05.
Oh, I'm sorry. There's good conservative math, eh?
Yeah.
Sorry, yeah, we'll do 2.5, 3 minutes each. All right, sorry. And Ms. O'Connell, you up first?
Thank you, Mr. Chair. And thank you to the witnesses for being here. Once again, unfortunately, we see how unserious the Conservatives are when it comes to cyber safety.
Point of order.
Ms. O'Connell, just a moment, please. Mr. Motz?
Well, you know, it's really quite interesting to hear that from the other side. Mr. Biddle, you can have your turn.
You don't have the floor. Okay?
Gentlemen, order, please. We're almost
You want to have
through
the
this.
floor, you can
Let's get through
ask
this,
for it.
Mr. Biddle.
On my point of order, Mr. Chair, it's really surprising that we have the narrative from Ms. O'Connell that speaks about our concern about cybersecurity. In fact, I think nothing can be further from the truth. The fact
This
is
is debate, Mr. Chair.
it's not debate at all. I'm making a comment.
Please.
That's literally debate.
Well, okay, so it's
Quickly,
debate.
your point.
Then what's going on
Mr.
over here?
Motz, let's retain order, please. Let's quickly get to your. You have a point?
It's debate.
You have a point?
Yeah, I do actually. I'm, you know, the comments can be subdued. The fact that Ms. O'Connell speaks for us is an embarrassment to the Conservative Party of Canada. She doesn't speak for us. We do take this matter very, very seriously.
Okay.
And
All right, thank you.
We'll see.
Thank you, Mr. Motz.
Thank you, Mr. Chair.
Move back. Ms. O'Connell?
Thank you. I'm only 12 seconds in. I'm keeping track. Through the chair to the witnesses again, apologies
I do want to
for
point out,
the...
Ms. O'Connell, just one moment, please. We did have a motion, not a motion, but an agreement that our last 9 minutes we've broken up evenly. So we will keep breaking them up as we're going. So how many minutes are left now?
I'm 22 seconds in. It has been interrupted for points of order,
you
so I
want-
have
I'm just-
3 minutes.
For clarification, you want to take the block and the NDP's time, or you want to divvy up what's
I
left
have
now?
3 minutes, which is what was agreed to. If your side would like to keep interrupting
Your
to
side-
shut
I'm
me
the
down,
chair
then
today, Ms. O'Connell. I'm not on the
it demonstrates exactly my point of how unserious you are about cybersecurity and anything dealing with crime and safety in this country. Go ahead. Cut my time, cut me off,
You're actually
silence
eating into
me.
your time. I'm not silencing you at all. I'm letting you speak freely right now.
So
Everybody's
I will
listening.
continue with, I've spoken for 22 seconds out of my 3 minutes. If you're going to try to silence me,
I'm not. Does anybody in here think she's silenced right now?
nobody
Keep
cares
talking.
about your poll, Mr. Chair. I'd ask
My
that you,
what?
your little poll, I would ask that you run a meeting as a proper chair, which is, I was given
Point of order,
3
Chair.
minutes.
Point of order.
Mr. Brock?
This is absolutely disgusting. It's unparliamentary on so many levels. The ad hominem attacks against our chair, members of this Conservative side, is deplorable. And Canadians are watching this behavior of Ms. O'Connell and Mr. Biddle. The only person we have respect for right now is Mr. McKinnon, who's actually taking this seriously.
Thank you, Mr. Brock. Go ahead, Ms. O'Connell. Continue, please.
Thank you. I'll continue because That's great. The Conservatives are doing the work for me in showing how unserious they are. So, Mr. Warnell, I'm going to try to at least get a question on the record because, and to all our witnesses, we're actually I'm very interested in amendments. The comments have been made about there are things that can be done to improve this bill, but overall, we need a cyber security plan to deal with critical infrastructure, which we're very open to amendments and having those conversations of where we can strengthen this. However, unless we hear testimony, unless we go through this process, unless there are questions and amendments suggested, we can't propose those amendments to the government. So this little demonstration that is here, this fake outrage, is really disappointing to see critical infrastructure at risk. And Mr. Warnell, I come from a host nuclear community myself. So the concerns that my residents would share around the risk of critical infrastructure around nuclear and supply chains, and you brought up actually at the very beginning the risk to cancer patients for the critical isotopes that are produced. Can you perhaps speak to not only critical infrastructure, but the upstream of the supply chain if the immaturity of certain members can't get through this process to actually allow amendments and our testimony?
Ms. O'Connell, can we please keep it professional and stop personal attacks on anybody in this room?
Mr. Chair, you're not the arbiter of what I say, and it is parliamentary. I still have a minute, and I would like the witness to answer.
You've got 18 seconds according to the clerk.
No, I have two. I've spoken for 2 minutes. You're counting interruptions from the Conservatives against my time. I'd like Mr. Warnell, who sat here for the duration of this meeting, to answer my question about the safety and security of critical infrastructure in nuclear communities. Oh my gosh, I'm so not interested in your opinion of my comments to get to a question about critical infrastructure in nuclear communities.
I was actually speaking to everybody, Ms. O'Connell. If you think that it's directed towards you, perhaps there's something going on there, but I was talking to our whole committee.
Perhaps you have an issue particular with me.
Ms. O'Connell?
Yeah.
Please.
You've interrupted my time. You have interrupted my time, Chair, time and time again. It's funny, you don't interrupt the male Conservatives, but the one woman asking question on this side,
meeting has gotten just
you
ridiculous.
interrupt.
I declare this meeting adjourned.